Hello, I'm Jim Turk, the Director of the Center for Free Expression at Ryerson University, and I'd like to welcome you to the 8th in the series of the Center for Free Expression's uh, uh, continuing broadcasts on Taming Big Tech, Exploring the Alternatives. Before I begin, I'd like to acknowledge that the land in which I am speaking to you today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Haudenosaunee, the Chippewa, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. And also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties signed by multiple Mississauga and Chippewa bands. Our conversation today will explore the issue, in the golden age of surveillance, can privacy laws save us? Our discussion today is being co-sponsored by the Edmonton Public Library, the Milton Public Library, the Thunder Bay Public Library, the Toronto Public Library, and the Vancouver Public Library. And I'd like to thank all 5 of our co-sponsors for their support and interest. Our guest today is Tamir Israel. Tamir is staff lawyer with the Samuelson-Glushko Canadian Internet Policy and Public Interest Clinic, or CIPPIC as it's known, at the University of the University of Ottawa's Faculty of Law. Tamir's digital rights advocacy includes parliamentary testimony, participation in regulatory proceedings, interventions at various levels of court, and interjections and to a range of internet governance mechanisms across Canada. Tamir's research interests are driven by social justice considerations and related to the intersection of law and technology, focusing on privacy, intermediary liability, consumer rights, and national security. Welcome, Tamir. In conversation with Tamir today is the host of our Taming Big Tech series, Andrew Clement. Andrew is Professor Emeritus in the Faculty of Information at the University of Toronto, where he coordinates the Information Policy Research Program and co-founded the Identity, Privacy, and Security Institute. Andrew has a PhD in computer science and has had long-standing research and teaching interests in the social implications of information communication technologies and participatory design. Welcome, Andrew.
Thank you, Jim.
Now, the format for today's event will be a conversation between Andrew and Tamir that will last approximately 45 minutes, somewhere between 45 and 50 minutes. Their conversation will go on. At that point, they'll turn to you, the audience, for any questions that you may have. If you look at the bottom of your screen, you will see a Q&A button, and you just click on that at any time if you have a question that you would like to pose to Tamir and Andrew. Don't wait till they turn to the audience 45 minutes from now to start thinking of your questions. If a question comes to mind as you're listening to their conversation, just click on the Q&A button, tap write in your question at that point. And when we get to the question part, Ange Holmes, the Center for Free Expression's coordinator, will read out the questions in the order that they're received. I think that's really all I have to say. We're delighted the 2 of you are here, and I'd like to turn it over to the 2 of you. Bye-bye.
Well, thank you, Jim, and welcome, Tamir, and welcome to all of you out in Zoom land, wherever you may be. I'm reaching you from my home on the West Coast in the unceded territory and ancestral homelands of the Salish-speaking peoples. I live near Victoria, which memorializes the imperial monarch in whose name this territory was stolen to establish what to this day we call British Columbia. We're able to have this conversation thanks to a remarkable digital network whose physical features belie its popular characterization as a placeless cloud. In North America, at least, the fiber optic cables carrying the signals between us still largely follow the railways that colonial agents pushed through the lands of numerous First Peoples. The data switching centers are located mainly in large featureless buildings at the center of our major cities, where these railways met each other over a century ago. This high degree of physical centralization of critical network infrastructure has greatly facilitated our signal intelligence agencies, the NSA in the US and CSE in Canada, to intercept all our internet communication and selectively monitor it for perceived threats, all in the name of national security. So, Tamir, I'm delighted to have this opportunity to talk with you on the timely topic of vital concern. In the golden age of surveillance, can privacy laws save us? I see you as one of a small but plucky, talented, and hardworking band of civil society advocates dedicated to fighting for the public interest in the digital rights realm. Person for person, you're worth your weight in gold compared to all the legions of others who have rather different agendas that you're working against. So I've had the pleasure and honor of having crossed paths with you at many privacy-related events over the past few years. I've always been impressed by your deep knowledge of the subject and insightful grasp of what's at stake. I'd like to start our conversation by unpacking the title of this session, which you proposed, and I think it's great. It's much better than one that I had originally in mind. So let's begin. What makes this the golden age of surveillance? Can you lay that out for us?
Yeah, that's a great place to start. And again, I just wanted to start. Thank you for having me here, Andrew. I look forward to our discussion and the center as well for hosting this. I should just mention that I am joining us from Ottawa, which is on the unceded territories of the Algonquin peoples. That's where I'm joining you from today in my apartment. Getting to your question, though, I actually think that where we're at is actually not yet maybe in the golden age of surveillance yet, but just on the cusp of the golden age of surveillance, which is yet to come, which may be a troubling thought for those of us who've been following along. I would say that the data landscape that we've developed together collectively, or that's been developed for us, I should say, is probably the least kind of conducive from a privacy perspective, as you could imagine. It's basically driven by an underlying business model that has maximized the accumulation, retention, and real-time mobilization of personal data at almost every turn. Now, given that that's where we've ended up with the tools that we have in place, as we start to shift towards what I think is going to be an even more aggressive landscape with more opportunities to really maximize the collection and utilization of data, personal data, or personal information, we have to ask ourselves if we have the right tools in place to make sure that we can really interrogate at a social level what's happening and how things are developing, and make sure that privacy doesn't get completely left by the wayside.
Well, I appreciate you pointing to the problem of surveillance, of the increasingly ubiquitous and penetrating intrusive surveillance. I hope we can be more optimistic than you, and that we're just not. The best hope is that we're not going to be pushed completely aside. Let's get into the most recent proposal from our federal government about how to deal with, how to update our privacy legislation. There's widespread agreement that our existing law, at least in the private sector, is called PIPEDA, the Personal Information Protection Electronic Documents Act, is way out of date. It came into effect in 2000. A lot has happened in the data industries in those last 20 years, quite remarkable ones. And so the government has, in a way, tried to respond to that. But I wonder what you think of it, and particularly in relation to whether that legislation, Bill C-11, also known as the Digital Charter Implementation Act, actually addresses the issues of our time, particularly if we're on the cusp of it getting even worse. Is it just a warmed over version of a model of data handling and protection and that existed in the 1990s, and they've sort of warmed up a little bit, or do you think it really it does the job? And if if not, what would you like to see when they bring it back to Parliament, as hopefully they will in the next couple of months, as they promised to do? What changes would you like to see? And we can take that apart in the rest of the hour.
Yeah, of course. So we do. So I think the proposals that we've seen for how to update our privacy laws they have, some important things that address problems in the existing regulatory framework and make, moderate improvements. They also, unfortunately, have some features that would make it easier for companies to accumulate even more data. And I think given where we're at and what's coming down the pipeline in terms of privacy, they need to really take an aggressive stance. There's a need to really take an aggressive stance in how we're dealing with privacy. So PIPEDA itself was developed in the early days of the information revolution, and what we're dealing with now is a multi-billion-dollar industry with really powerful incentives and capabilities that individuals are very hard pressed to navigate and press back against. And we need a regulatory regime, a modern regulatory regime with modern tools that really is up to the task of this. Now, there's a lot of things in the law that I think could be improved, but maybe a good place to start is its overall framing and its overall approach to privacy. Mm-hmm. Now, there's been discussions, the Federal Privacy Commissioner has called for this, and others as well, of the importance of taking a rights-based approach to PIPEDA. Currently, our law is embedded in its overall approach to regulatory approach and how it's going to be applied is this idea of the need to balance privacy as one interest that's basically on par with with other types of more pragmatic considerations like business interests and business needs. But there's a problem here because because of the stark imbalance between the abilities of individuals to assert their privacy rights and the abilities of companies with really powerful incentives to shape the entire infrastructure on which we're all interacting. Simply, this balanced approach doesn't, this equal footing for things like privacy doesn't allow for the correction of that imbalance. You need more than that. So one thing that we've been recommending, and others as well, is that it's an important component to really getting a law that's going to provide us with the tools that we need to address the challenges that are coming ahead, is to make sure that privacy is first and foremost in the application of the various powers it has. Now, our courts have already recognized to some degree that PIPEDA is a law that is there to protect a right. So, and that's a fundamental right that's protected, and that's in our charter, which is an important step. And that's something that I think we can build on in the legislative process and can have a lot of spillover effects for how this law is ultimately applied.
Yeah. So you're touching on the issue of sort of declaring privacy as a fundamental human right, and we've accepted that. Canada has nationally, but I understand that there are problems of actually working it into legislation that ostensibly is for the commercial sector, which is provincial legislation, and the stated purpose of C11, it's the same more or less as PIPEDA way back when, which was that it is to support, I'm quoting, support and promote electronic commerce by protecting privacy and hopefully developing trust. So right there in the framing of the legislation, you've got, actually, I would read that as the primary purpose is commercial interests, and we've got to help people become more trusting of the electronic commerce environment, which, maybe had some justification back in the 1990s when this was developed. But we've seen how electronic commerce has developed since then, and that has succeeded for better and worse in quite remarkable ways. And yet it's continuing to be the stated purpose of C11. What would you like to see as the purpose of a reformed and up-to-date privacy legislation?
Yeah, so I think, so there are some constitutional challenges in Canada that, in the sense that our constitution a lot says that provinces are responsible for addressing human rights. Now, whereas the federal government is allowed to regulate things like commerce. Now, I know that some folks have stated that this imposes limitations on how far we can go in really embedding this, this privacy as a human right approach in PIPEDA. I've heard very convincing arguments. My colleague at University of Ottawa, Teresa Scaza, has a very compelling legal analysis that makes the case that you could actually do this in the context of privacy in the internet. I think you would still need some nexus to e-commerce to kind of ground it,
Sure.
to ground what's happening. But I think you can though encode the indicia of what's important in a privacy and human right approach. So first of all, you can rephrase that phrase that purpose clause that you just mentioned, and some of PIPEDA's core elements that require that embody what a human rights approach looks like, by ensuring that privacy is given preeminent protection when individuals interact with e-commerce platforms, for example.
Yeah.
You can encode and make it an override consideration that human rights conceptions like proportionality, necessity, fairness, dignity, that these are overarching considerations that have to occur when a regulator is assessing what a company is doing and what is and isn't appropriate in a given circumstance. So there's ways to do this, I think, and that haven't yet made their way into the drafts, that get around, even the more skeptical, maybe, approaches to the constitutional question.
Yeah, good. I mean, I found it remarkable that there was no updating of the purpose, and looking at Bill C11 from the point of view of the changes that have happened since 2000, and particularly the growth of surveillance capitalism, as Zuboff has called it, or the ad tech business model that many of these platforms have adopted, where it involves the extraction of personal information in a variety of, often covert ways, and then using that as a basis for feeding you content or recommendations or ads, which is where they make their, enormous sums. My reading of it is that it does that this bill does very little to actually address that as a sort of the central current privacy challenge, which you've mentioned. Even the Privacy Commissioner of Canada has said that this is actually a step back, and I'm quoting. So that was pretty disappointing. It's amazing that the commissioner has to, after the fact, come out with that. So I wonder, since this is a series on taming big tech, I can't help but think that perhaps the big tech industry, has had its sort of fingers on the scale, so to speak, or the ear of the drafters of this. And in particular, I guess I'm struck. Just last week, there was an article in the Toronto Star entitled "Canada is sleepwalking into bed with big tech as politicos float between firms and public office," and it talks about a study that was done through McMaster University, but points out that there is a significant amount of what is referred to as regulatory capture by the industry, where industry and government people move back and forth and sort of basically at least to develop a shared worldview. And I'm struck that the Facebook Canada's head of public policy was formerly the director of policy and research at the Office of the Privacy Commissioner, and almost and the same thing at Google Canada. The head of public policy and government relations was a former director of research, education, and outreach at the OPC. Do you think I'm being overly skeptical here about the role that big tech is playing in the shaping of this draft legislation? And if so, what can we do about it?
Yeah, I mean, it's not just big tech. I would say our telecom companies have
Sure.
very large, significant interest in not having too aggressive privacy protections also, and they've been demonstrated, particularly in that report as well, to have very deep ties to lobbying efforts. I would say that the Privacy Commissioner's Office itself, I would say in my experience, has actually done a pretty good job with the tools it has to date. Those tools are deficient, as the Privacy Commissioner himself has mentioned, but I think we can point to a number of examples over the past year where, given the tools they have had, I think they've done a decent job. I think this idea of this concept of idea capture is a bit more problematic, and that I really do think that the drafting of this legislation does show this sort of commitment to a certain way of regulating privacy, which is one that I think is demonstrably not necessarily done. It doesn't provide the Privacy Commissioner and entities like it with the tools it needs to really try to equalize this very dramatic imbalance and these powerful incentives in this business model that really is just about consuming every piece of data that you can get at from everywhere. So I think that is really what needs to change if we're going to get a much more kind of aggressive, or a much more innovative set of tools. And we can look to other jurisdictions as to what these might look like, right? So in Europe, they've had the obligation to impose the obligation on companies to conduct data protection impact assessments, and if there's whenever a new and serious practice is being undertaken, and even get the regulators there involved to make sure that what they're doing is on board. And this these types of more innovative regulatory tools, I think have become common practice in jurisdictions abroad, but haven't really made it into our framework. And I think it's in part because we have this just this commitment to a particular way of regulating privacy that is just not keeping up with what's happening out there.
Yeah, I quite agree. A bit of the irony there is that impact assessments, as Colin Bennett has pointed out, were invented in Canada, and they're common in other areas, like in environmental, regulation. Yet we don't insist on them in the private sector, even when there could be quite significant, and we are seeing the quite significant implications. Earlier this week, the Globe and Mail had a piece it was titled Google Executive Cautions Canada Against Adopting Extreme New Internet Rules. Now, that article wasn't very specific about what areas, and it could be around online harms, and there's a lot of discussion about that right now as to whether that's appropriate legislation. But you've said that we need to be much more aggressive about this. Do you think we should be prepared to risk Google treating this as being too extreme, or are we actually asking for something that is relatively, I would say, middle of the road by at least European standards and elsewhere?
Yeah, I mean, I believe that article was referring to some of the more aggressive legislation proposals that we're seeing in the in some other contexts from this government. And I'm actually find it very disappointing that our response to privacy is so lukewarm compared to the aggressive stances we're taking when it comes to trying to protect our cultural industries and address so-called online harms. I think there's a lot. I think we should be willing, to a certain degree, to push back on to extend beyond international norms and adopt very powerful protections where important values are in place. I think, again, keeping in mind that privacy is a human right and one of the most fundamental, one of the ones that are at greatest most fundamentally challenged in the ecosystem that we're dealing with. I think a more aggressive posture is very warranted in this context. But even putting that aside, there's a long way to go in terms of improving the privacy, in terms of adopting much more robust privacy protections for what we saw in C11, without putting other important values like freedom of expression or in place, and still allowing room for innovation, right? Like the European Union regime, our international companies are dealing with it. They haven't exited exited Europe. They've found a way to incorporate it into their services. Why should people in Europe have more privacy rights than us?
Yeah, I mean, Google and Facebook do push back, and they've been fined very heavily by European authorities, and they're fighting those fines. But they have found a way to live with the GDPR, the General Data Protection Regulation that Europe has developed. One of the areas of C11 that has attracted quite a bit of attention is it's known as legitimate commercial uses, and what the draft legislation calls for, or allows for, is for weakening the consent requirements if you've got a legitimate purpose. And the GDPR does have the same kind of general concept, but a much stronger and more robust definition of that. What do you make of the legitimate commercial uses approach within C11? And do you think that targeted advertising based on information extracted without knowledge and consent would meet a good definition of legitimate commercial use?
Okay, so I'll start with the first half of that. So the key thing that's important in the European approach that I think is missing from our approach is that the European approach still generally requires you to give people a right to refuse practices that are legitimate. Our approach is essentially a blanket exception. So so it allows companies to do it's almost a blank check to do quite a bit, and not just to use information that they already have in ways that are problematic, but to even collect new information that they don't already have. Now, there's specific examples of how this might play out that are problematic that are itemized in our kind of exception to consent here that I think are going that I think are going to be particularly problematic. But the entire exception, I don't see there's not really a need for it as far as I can see, because PIPEDA again has been in place for a while, and it hasn't. I haven't heard anyone raise the point that consent is really creating an obstacle here, let alone in other jurisdictions, for businesses to accumulate and do the things that they need to do so far. There may be in like isolated instances it has pushed back on things, but those are I think well defensible. But this type of exception is but one of the things that's specifically itemized, for example, in this exception that could be really problematic is in any instance where a company doesn't have a direct relationship with an individual, they basically have a blank check to collect their information as long as there's some sort of balancing exercise going on. Now, first of all, this is left mostly to businesses to sort out. So, and you're not going to know that you're captured by this because you have no relationship with them. And PIPEDA remains primarily a complaints-driven process. So until there's a complaint, this doesn't even get interrogated as to whether, there's a balancing requirement there where the business does have to say that what they're doing is proportionate, but the business does that on their own until there's a complaint. So that's a problem. But even if you get this before, the regulator, and again, this is going to be subject to review by the courts, this type of exception is problematic. I would argue that in situations where you have no direction with the business is where you would want the most protection, not the least, and where it's most important to make sure that there's some sort of consent going on. One example of this, of what this might legitimize, is the third-party tracking ecosystem, which is gotten, which basically allows for endemic tracking of online browsing by third parties that you have no interaction with, and that really don't actually offer a lot of value in sort of, if you're looking at it in crass economic terms, whereas, but create very, very massive information and intrusive information stores on everyone. Other examples of where this might be a problem is, we've had a recent decision against Clearview AI for basically scraping a bunch of images from the internet and creating a comprehensive facial recognition capability. Now, the privacy commissioner in that instance said, they failed to get consent. So they maybe wouldn't do that because the information they were collecting from your Facebook profile and from your LinkedIn profile was information collected. They don't have a relationship with you, so they would fall within this business activity that C11 is trying to exempt. So they wouldn't need to meet the consent requirements in PIPEDA if this was in place. Now, the privacy commissioner also said that this was a disproportionate practice. So maybe there's something there that would carry over, but by explicitly saying that this type of, like writing in the legislation that these types of interactions need to be accommodated, more aggressively without the need for consent, you're opening the door to interpretations by either, the privacy commissioner, there's a tribunal that's going to get appointed, and there's, it's not clear who's going to be on that and whether that's going to be there's going to be lobbying against appointments there, or the courts eventually are going to interpret it in the same way that the privacy commissioner has to date. So it really opens a door to a lot of very intrusive collection. Part of what's developed in the ecosystem as it is that there's, as we know, there's so much more information about people out there that's public in a sense, but still covered by PIPEDA and protected, that there's just massive opportunities for companies that have no relationship with anyone to leverage this information in ways that are incredibly intrusive. And I think that's an area where, in particular, we really need to step up the protections, not roll them back.
Yeah, no, you've mentioned a couple of times this third-party tracking ecosystem, which is largely invisible. I mean, when you go online, particularly if you're using, mobile phones, there can be, dozens, even hundreds of trackers that are put, on your devices that will follow you around the web, whatever sites that you visit or whatever you enter on that, and that then gets is the grist for this industry that packages and aggregates and analyzes it and is then used for serving you ads. And that exception to consent, where the organization doesn't have a direct relationship with you, just seems to me flies directly in the face of what we need to do in order to bring this kind of ecosystem at least within some modicum of public oversight. So transparency requirements are one of the standard features of privacy legislation, and C11 has some. I personally think that they're rather weak, but I would like to see whether we can make that ecosystem much more visible, not just to the individual, because that also has a problem of overwhelming people, but at least to the regulators, to the advocates, to those organizations that try to protect people's privacy. So one of the things I wonder if you would comment on is, should companies that handle significant amounts of personal information be required to register in the way that many other areas registration is required? In Toronto, and I guess in most cities, hot dog street vendors have to register, they have to pay a fee. There's all kinds of things, and you can argue that maybe that's gets overly bureaucratic and there's a risk there. But at this point, given that personal information is in some ways our most vital asset, it's comparable to sort of money in terms of its importance to our life chances, and that we need to maintain control over it, and the Digital Charter Implementation Act, as this is C11 is called, seeks to fulfill the Digital Charter. I mean, like most specifically, Principle 3 of control and consent, which states that Canadians will have control over what data they are sharing, who is using their personal data, and for what purposes, and know that their privacy is protected. It seems to me that in the absence of more powerful ways of finding out who has your data, such as registration, that's done in the UK, but hasn't been done here in North America. What do you think that would be one way of achieving a much better transparency, and what other ways of transparency do you think would be most appropriate that don't burden the individual so much, but put the responsibility onto the organization?
Yeah, I mean, I don't know that UK has an open-ended kind of registration obligation. What I've seen is that might be really effective, though, is some states have adopted obligations for data brokers to register, and data brokers again are their entire business is to accumulate massive profiles and resell them on individuals without having any direct interaction with them at all.
Yeah.
So, and given that most data brokers are operative in the US and have already managed to find ways to comply with this, what's been set up is, you have a centralized portal then where all the registered data brokers are listed. And if you want, you can just go there, search across all of them in one spot to see if your data is in any of them, and then if you can exercise your rights to consent vis-a-vis those data brokers. Say you want to delete it, you want to opt out of their collection infrastructure. You have you can first of all discover that you're in these data brokers. Very, very wide and deep data stores, and exercise your rights to be removed from them. Other transparency mechanisms that could help is, we talked a little bit about impact assessments and how the process kind of developed out of Canada's like emerging accountability framework, but hasn't really been formalized here. And here they're mostly done internally, whereas in the EU, there's the obligation to actually submit an impact assessment to a regulator if a practice is particularly intrusive or systemic or novel. Now, an impact assessment is basically an obligation to, as you're developing your new and exciting innovation, make sure that you're taking into account the privacy considerations. And it's actually something that helps businesses on the one hand, because having to figure out the regulatory compliance, 5 years into the development process is not good. But it also is really critical for this transparency question where the development of all these tools happens internally without any public input or independent scrutiny at all. So like following the European GDPR requirement to submit these types of impact assessments around more intrusive tools, maybe tools that use biometrics for really sensitive data like that, I think could go a long way at getting at that. And then one thing in C11 that is kind of a starting point at a particular class of transparency challenges is the algorithmic transparency obligation that it puts in. Now, algorithmic, as we are well aware, algorithmic tools are increasingly used to make decisions about people. AI is the catchphrase. And often these decisions, often it's applied by companies to automate a lot of decisions that then impact people, and to increasing degrees. And often this automated decision making is very opaque, and it doesn't allow for the type of discernment that happens when a human being is in charge. And for individuals who are caught up in this, they often won't know that they're being, the reason that they've been refused a loan or a credit or a new service that they're asking for from their company or whatever was due to this algorithmic process. They won't know how to challenge it. When they call into customer service, they won't know how to that this has even happened. So transparency around that particular type of tool, I think AI systems been really useful. It would be a useful addition, and there's been one proposed in C11. I'm not sure it goes far enough, and we could discuss that, but that's another, I think, mechanism where obligating companies to be transparent about that particular type of use of information is important as well in getting more transparency.
Yeah, I mean, you mentioned the term AI for artificial intelligence, and fortunately, I would say that the Bill C-11 doesn't actually use that term, because I think many of the issues that you're mentioning around being able to find out or understand how you've been categorized, how you've been profiled, go way back, decades, that have nothing to do with the current round of AI, with deep learning, deep neural networks and machine learning and those sort of fancy techniques that have got so much attention. That this is an opportunity to actually bring some more transparency to long-standing practices, even when they involve humans that are perhaps involved to some degree in the system of categorizing you and putting you into different treatment groups, or that influence your life chances, like in employment or loans and these sorts of things. That has been opaque for so long, and hasn't been part of privacy regimes, at least in Canada. So I think that's a really good move. But yeah, Tamir, you have something you want to add there?
Yeah, I mean, I think it actually, so I would say accuracy of information and information processing has been central to privacy in Canada and abroad. And Canadian tools have been used to try to challenge, for example, like credit scores and uses of information like that in the past under PIPEDA. Now, the challenge has been some of the commercial secrecy around these tools and how they're used. And that's been a challenge, and how PIPEDA has been applied in those contexts has been a challenge. But now that these assessment mechanisms are, getting to a place where they're, a little bit out of control. I mean, where they're making such sweeping determinations about people, well beyond where they've been historically. I think that, really expanding that kind of accuracy component of privacy, and like making sure that your information is being used about you in an accurate way, is going to be central to addressing, how we're dealing with these things moving forward, and to reining in big, some of the technology companies out there, because increasingly we're shifting towards, this is the data mobilization component of the business model, right? Like there's advertising, which is obviously like where a lot of the money comes from, but we're shifting towards we're seeing in a lot of places where the value, governments are looking to private companies to pay them to, analyze their data sets to help with, with assessments of social services, and with all these various other types of, things that were historically done by government. And there's going to be more increasingly powerful incentives to turn these assessment tools on these data sets that have been accumulated to achieve a whole host of reasons. So I think for those reasons, I think privacy is a good place to extend this historical kind of commitment to accuracy.
Well, yes, I agree that, having the data being accurate, I mean, is important and foundational, but I think the issues go far beyond accuracy, and I would not like to see that discussion stuck in an accuracy argument. So, when you're categorizing people, I could be legitimately categorized as an old white guy, but then what's the category scheme for which that's relevant? I mean, how are we being sorted socially? What are those categories, and are they actually socially beneficial, or do they reinforce existing social inequalities? And that is not something that accuracy gets at, and that, to me, I think, is a more fundamental question, which an accountability impact assessment, as you're saying, around algorithms, and also where you're getting the data, need to focus. There's been a lot of work, and we'll touched on it in actually our last session with Wendy Chun about how discriminatory systems, do reproduce many of the I guess the social maladies. Just because they show up in the data, they become predictive of how people are supposed to be act, and they really could be quite damaging to people if you're stereotyped in ways that may be accurate from a data handling point of view, but are really inimical to when you look at these category schemes and how that whole mechanism works. So I
Yeah,
hope we go
absolutely.
further.
I think that this is where I think as well that kind of reconfiguration of the objective of PIPEDA is this like human rights based mechanism, and specifically incorporating concepts of fair processing, proportionate processing can go a long way. And I think again, and I think you're absolutely right. And the problem of this categorization thing, I think one step again that's been taken in the European privacy regime that I do think we also need to take on is just a full-out ban on automated decision making that's going to lead to serious consequences for people, for individuals. Like have a human involved in that decision, and I think that's a core kind of privacy mechanism to have to make sure that decisions are both fair and accurate. Because and we've had so many examples of this where any sort of automation, even if it's not the more recent and maybe a little bit hyped up AI that I think you're right is really just maybe like a more far-reaching example of something that's been around for a while. We've had examples of where that's gone very massively awry, right? So Australia, for example, the government has adopted a very kind of, and in the government we have a little bit more scrutiny of these, so that's where a lot of the examples come from. But they're often the same kind of things that companies are doing when they're assessing their customers these days, and the consequences could be just as serious. So Australia, for example, adopted a automated mechanism for assessing whether people who receive social services got overpaid, basically. And this automated process obscured so many of the inputs into the decision that they didn't realize for 3 years that that the data that they were using to assess people's claims for social services was based on annual tax assessments, whereas the actual claims for social services were based on bi-weekly income checks. So there was always a discrepancy because on one hand, you're getting an average of an annual income, and then on the other hand, you're being assessed based on monthly paychecks that are fluctuating week to week. So the result of this, it took over 3 years, almost 500,000 Australians had hundreds of millions of dollars clawed back from them, and it took 2 lawsuits and a class action before the government reversed course on this, and it all because it was they were relying on this automated classification system that required a simplification of what they were dealing with in a way that didn't really match up to reality and really obscured what was the types of decisions that were being made. I think it's that type of decision making and automation that there really isn't, our law hasn't really developed in a way that deals with it very clearly. And even Australia, right, the lawsuits had trouble in framing why this was a wrong based on the general kind of laws that we have in place and protections that we have in place. So I think banning, this type of personal information use within the context of a privacy law is critical. You can still rely on automated decision-making tools, even that can still be problematic, right? So we still need to have all these other safeguards in place to make sure that the tools are working properly, that they're not racially biased, as too many of these tools are, whether like in any accurate sense or in a way that perpetuates stereotypes. But just even making sure that really important decisions about people made by companies on a daily basis aren't fully automated, I think is another thing that we should really be borrowing from our EU counterparts.
Good. One of the things that's actually the headline announcement around C11 in terms of how it's making its much stronger privacy protection is that the Office of the Privacy Commissioner, or the Commissioner, is given order-making power and also the ability, I guess, to recommend certain kinds of fines or administrative penalties up to, I forget whether it's 4 or 5% of global revenues. This echoes the GDPR in this matter. You mentioned earlier that the Privacy Commissioner's office does a reasonably good job given the resources that they have. But I wonder whether for an agency that has an annual budget of around $25 million a year, and which has been relatively static for the last 10 years, it would actually be able to sort of wield a club or whatever, a scalpel, to take on these giants. $25 million would be nothing to them. Facebook, sort of sloughed off a $5 billion fine from the US government, and their stock price went up when they announced that that's what they were paying. So what do you think would be required, not so much in the legislation part, but in the data protection regulatory regime more broadly, in order for this legislation to actually have some effect in terms of big tech and the surveillance business model?
Yeah, so I mean, I do think that the ability to issue penalties and as well as to actually issue binding obligations onto companies is important. Not having that, I think, puts our privacy commissioner at a serious disadvantage.
Yeah, sure.
I also do think it does have some incentivizing effect. Obviously, it's the bottom line now has really definitely kind of moved beyond to smaller fines, or even what most people will consider very massive fines. But it does actually help elevate these types of considerations in internal decision making to some degree at least, and makes people more cautious. We have, for example, on the parliament, in the development of the parliamentary record, we have examples where the Canadian Privacy Commissioner's office asked a multinational tech company to make a change as part of their process of applying PIPEDA to this company, and were basically ignored. And then the German regulator, who does have the power to issue fines, asked for something almost identical, and they did it. So I do think that it is important to actually have this tool in the toolkit. Not having it is a problem.
Yeah,
it's not
sure.
enough. And particularly, I should say the version that's in C11 is really problematic, because it actually two of PIPEDA's core protections, the obligation for consent and the obligation to have a proportionate kind of proportionate data handling, don't qualify for the penalties, and I think that's a serious flaw.
Yeah, wait, why is that? It doesn't make any sense.
I think it's a serious flaw and creates counter incentives, if anything.
Yeah.
So that needs to go. But it's not enough. I think adopting a more regulatory stance, I think, would allow the Privacy Commissioner's office to really dig into some of these problems that we see emerging all the time in a more proactive fashion. So we have other regulatory bodies that can do this. You convene a formal process. The public has input. The companies that are involved in the practice, can defend the practice and explain how it works. That kind of thing, as opposed to the complaints-driven mechanism that we have now. Now, the OPC has, in places and at times, adopted kind of proactive policies in spaces, but they've done it informally, and because PIPEDA remains a very complaints-driven process, and they can provide that sort of supplement when you're talking about practices that are already well documented publicly. But when you need to discover how something works at its kind of early stages, and there's not really a way to do that, you need something more robust. And I think this regulatory approach might be a way of getting there, and also a way for the public to have a say. The complaints are all mostly internal, right? Between someone files a complaint and the OPC deals with it and the company, but the public is not involved in that process as they are in some types of other regulatory processes. So I think adding that to it would be a really kind of helpful step forward.
Yeah. I was also looking to see that the OPC had the resources, the expanded resources, and that's partly what I was getting at, because right now, even just to submit a complaint takes ages to get response and so on. So I think they're stretched. So we're running out of time here. So I just want to, before we go to question and answer, I see a number of people have already asked questions. Tamir, what would you recommend people to look at if there was, one source that you or a video or whatever? What do you recommend?
Yeah, so I mean, I've been reading. I have a few. So one is Sophia Nobel's algorithms.
Yes. Okay.
Actually, I know this has already come up. Rue Benjamin's Race After Technology. I have a book by the late great Ian Kerr called On the Identity Trail. Which
yes, of course.
It has a lot of very valuable insights.
Yes, your
I have two
former
more.
colleague.
Virginia Eubank's Automating Equality. And I would recommend people visit a website by Canadian documentary artist Brett Gaylor called DoNotTrack.com. This is basically a documentary that's tailored to you, so it'll basically use the online tracking tools, with your consent, of course, that are used by industry to tailor a group of informative videos that explain to you how. Yeah,
it's a very clever one, and quite engaging. It's really quite terrific. So we're time for questions, and Ange, can we have the first question, please?
Yeah, the first question is from Elena, and Elena asks, for those of us new to this, what does the acronym PIPEDA stand for, and precisely what does it cover and what does it not cover? And a related question, what legislation covers privacy in relation to things not covered by PIPEDA?
So the acronym stands for Personal Information Protection and Electronic Documents Act. The electronic documents component has to do with letting people sign things electronically and isn't really that relevant to privacy. C11 would rename it the Consumer Protection something and Privacy maybe Act.
Canadian Consumer Protection for Privacy Act.
Which I think is maybe, I think there's other maybe better names for it that focus more directly on privacy that should be explored as well. What it applies to is, and I think other folks have touched on this, is the collection, use, and disclosure of personal information in commercial contexts. What that does not include is, for example, so includes employment contexts in federal in certain industries like ISPs and maybe railways, but not generally. It doesn't generally govern employment. That's left to the provinces where there are provincial laws in place. And it also doesn't cover things like political parties, which is federal political parties, which is an increasing problem because federal political parties increasingly leverage this vast data infrastructure in ways that are deeply problematic.
Okay, thanks, Tamir. Ange, and next question.
Yeah, the next question is a multi-part question from Ramon. Ramon asks, does PIPEDA cover only relationships between businesses and clients? Is there any coverage for relationships between individuals? For example, between an individual who is a landlord having camera and or microphone surveillance? As well, do privacy of information laws in Canada only cover Canadian citizens? Are international residents covered by the privacy laws?
Yeah, so landlord, it does only apply to businesses, but like what, or to commercial, I guess, interactions. So it won't apply to say you and your, so if your parents installed a camera in your let's say your space, that wouldn't be covered. But it does apply to, but commercial has been given sort of a very inclusive interpretation, although this is being litigated in the courts right now. Specifically, landlord-tenant relationships have been held to be commercial. So it does. So PIPEDA would apply in that situation because your landlord is renting your apartment to you for money. So that is that's covered.
Thanks. Ange, next question.
Yeah, the next question from Garth. Garth says, in these conversations on taming big tech, I sense an avoidance of treating Canada's primary communications carriers as big tech. Given the powerful role they've played in shaping internet policy and regulation in Canada, is that a framing problem? Does that, or how does that shape the understanding of mechanisms for taming?
Yeah, I mean, I would say that, I mean, the series, I think that they are a big tech of a sort. I do think that they raise many of the same challenges that multinational companies raise. That are, multinational companies, I think, are the focus of this series, which is maybe why you're hearing a bit more about that. But I do think that they raise a lot of the same problems. The lobbying by our telecommunication companies is very intense in Canada. Their willingness to really push the boundaries on how they're leveraging data and their customers' data is growing. Some of them, TELUS in particular, is also like a health data company now, right? So I think that's a very kind of well-phrased question, and I think it's important to keep them in mind as well as these multinationals. And just to return to the question about how PIPEDA applies abroad, so it definitely applies to companies that are based abroad, as if they have like a substantial, let's say, consumer substantial. If they're collecting data from a substantial kind of volume of Canadians, to the degree that it protects the privacy of individuals that are not in Canada, I think that's a bit of a more challenging question, right? So if you're in the US, right, and you're dealing with, let's say, a company based in Facebook or a company based in the US, I think there it's kind of a tougher argument to say, PIPEDA could apply in that context. You'd have a hard time filing a complaint with the privacy commissioner there. That being said, we have seen frequently that when one regulator kind of say our Canadian privacy commissioner requires a change in how Facebook addresses a certain type of data, very frequently they'll apply that change across a lot of their services. So, and in part because it's hard for them to justify, doing it, giving Canadians more privacy than some of their other users, but also because it's just kind of in the nature of the services to often apply these changes holistically. That's not true across the board, but
Ange, can we have the next question?
Oh, I think that you froze, Andrew. You're frozen. Tamir, you can continue with.
No, I think
if you want. Was that okay? Okay. The next question is from Brian. Brian asks, it says, you've talked a lot about the private sector, but could we talk a bit about public sector privacy law reform? Specifically, it would be interesting to hear your thoughts about the recent incident of the federal government accessing the mobility data of Canadians. It appears they got this data from TELUS. This highlights some of the issues with the sharing of personal information between the private and public sectors. Would harmonization help clarify these issues and build trust?
Yeah, so I think it's a really good question. I think those boundaries are eroding a lot, and that's a good example of the way that private, data that's accumulated in the private context just gets leveraged to achieve a lot of public policy objectives increasingly. There's another example from a couple of years ago where StatsCan got financial data from banks on millions of Canadians as a way of, the kind of shortcutting the need to ask Canadians certain questions the way that it normally historically does. And StatsCan has also, increasingly looked to leverage to try to get authorization to leverage, data from Facebook and Google that is private currently to achieve its goal. And in other jurisdictions, we've seen kind of governments again like proposing to leverage a lot of the data that's been accumulated by these private actors to achieve a wide host of of public objectives. So I think harmonization could address that to some degree. I don't know that there's an appetite for that in Canada, so it's challenging, and some thought would need to be put into how to reformulate some of the different components of our private and public sector law. Our public sector privacy law is also massively outdated, but also I think strengthening, within our law reform efforts, the restrictions on when data can flow from a private company to a public company to the public sector would help. And specifically, so that with it, and another thing that we didn't really get into that needs careful attention is, so part of TELUS's justification is that the data is, to some degree de-identified. So they're I mean, not to put words in their mouth, but PIPEDA is not, our privacy laws have not done have found this always to be kind of a challenging area to address in a way that's really robust, where data is, because increasingly you're able to, maybe disassociate data a little bit from specific individuals and aggregate it in a way that can still have really, really extreme consequences for those individuals. But then the argument is often by the people wishing to use the data is that it's no longer covered by privacy laws. So I think like addressing that as well is another way of maybe forestalling some of these more problematic information sharing paradigms that are coming up.
Yeah, and this is an interesting point. I mean, this is part of what makes this the golden age of surveillance, or the cusp of that is the huge accumulation of information through the private sector that then becomes a sort of a honeypot for government interest, and we don't have very good regulation at all for dealing with that as well. And C11. You can correct me if I'm wrong, Tamir, but basically repeats the previous regime in terms of what government can access and not, and with very little oversight, it appears.
I think it would even expand it. So there's one exception for socially beneficial information sharing, where again you would get, to the extent that there is a consent requirement, that you need to get consent before sharing this type of information with government. If you consider that the sharing is for a socially beneficial purpose, and you meet certain levels of de-identification, et cetera, then you don't need to get consent. And again, that's a very big problem. We have, the example that Brian mentioned is a good one of how that could be leveraged. But we also, and another one would be that we had the Sidewalk Toronto initiative, which I know Andrew is very familiar with, and we've heard about in the series before. But again, like the principle there was to accumulate, develop an entire neighborhood that's inundated with sensors and collects information on everyone at every turn. Makes it a little bit less linkable to those people on an individualized basis, but then put it all into a centralized entity and allow a variety of entities to access it for whatever is deemed to be socially beneficial, and then leverage it and use it in ways that really impact those people. So so I would say on that as well, the C11 creates more opportunities for this type of privacy problem, not less.
Yeah. And next question.
The next question is from Sebastian. Sebastian says, many experts point to GDPR as the gold standard that should inspire Canada's PIPEDA reforms. However, there are several new frameworks and reforms coming down the pike in Europe that pertain to the digital economy. Which ones do you believe Canada should pay attention to either for inspiration or implications?
So, I mean, I think there's a lot of problematic frameworks around, what to do with other types of online discourse that are are deemed undesirable. I think those can really go awry because they're very content specific, and we have a lot of data to show how those can go awry. And Canada is drawing inspiration from some of those proposals, I think, to our detriment. But with privacy, I think there are some specific proposals beyond the GDPR that should be incorporated. Particularly ones related to how information is leveraged by I won't say AI, algorithmic and other automated decision-making systems. So I think we mentioned a couple of them as we were going through, but one proposal, for example, that would ban AI-driven or algorithmically driven mass surveillance in public spaces, for example. I think that's important. Often algorithmic tools are used to allow just real-time surveillance by companies of customers and what people are doing in ways that are deeply problematic and wouldn't be really feasible without this type of assistance, because there'd be just too much data. So I think considering a version of that would be really helpful, because I think this type of surveillance can lead to mostly problematic things and not a lot of good. There's proposals to ban the systematic treatment of individual or groups based on factors that are not actually contextually relevant. So this starts to get at like social scoring based on random criteria. There's a lot of pseudoscience out there that is really getting a lot of buy-in from a lot of companies in both employment contexts and customer engagement in other contexts. Phrenology is back, like the idea that we can deduce what people are thinking or feeling, or whether they're lying or not based on their facial expressions, for example. There's no scientific basis for this, but a new host of automated tools is convincing companies increasingly that they can just apply these in ways that make decisions about people. Other types of social scoring where people are assigned trust or risk scores based on factors that are not really in any way really relevant, and often lead to racial discrimination, other types of discrimination. These are all cropping up, and there's EU proposals to put very concrete and explicit limits on those types of tools in a draft AI regulation that's been floating around. I think these are all worth deep consideration. And also some notification obligations. For example, in that same proposal, one of the things that's in there is that you would have to expressly notify individuals whenever you're processing their data using automated means, and specifically notify them whenever you're doing any sort of emotional analysis, automated emotional analysis in deciding how to address them. And finally, there's a provision that would ban the use of AI to kind of dynamically change interfaces, user interfaces on websites and other types of interactive mediums in ways that are designed to manipulate people to act in particular ways. I think all of those are really worth taking a closer look at in a Canadian context.
Great, thanks. Yeah, Ange?
Yeah, the next question is from Lou. Lou asks, do you have any concerns about the COVID alert app that is supposedly being used to assist in identifying those exposed to the virus? It does seem potentially useful for public health.
Yeah, so
Yeah, good
that
question.
one, it's a good question. Okay, so I think the issue there is, I don't know that it was as effective as it was initially hoped, and there were definitely some implementation challenges with it. I think it's good that the government turned to the Privacy Commissioner for help in assessing this tool and whether it had the proper amounts of privacy safeguards in place. Now, I think it actually points, though, to a more systemic problem, which is that there was actually no legal requirement per se for the government do that. And I think that that is a flaw. It's not a flaw with PIPEDA because this is a public sector tool, but our public sector regulatory framework is also, at least as outdated as our private sector framework. And I think, again, like we really, what's important is to have the regulatory tools in place so that there's a concrete obligation to really critically assess whether a tool like that has the safeguards it needs to have in place, so that the public should also have a say in the process of assessing whether taking on a tool like that could be potentially intrusive, is aligned with what they're, is proportionate, et cetera, and you can create a regulatory structure and the right types of, and encode the right types of rights and considerations in place that allow for that type of critical assessment to happen. But we don't have it now. And that, I think, for me, was the biggest concern with how that tool got rolled out and adopted.
Ange, the next question, we still have quite a few questions and we're probably not going to be able to get to them all, I'm afraid, but we'll do our best.
Yeah, the next question is from Rosemary. Rosemary asked, have either of you looked at access to provincial health records used for academic study, accessing in secret ICD code at billing as proxy for patient diagnostic data without consent as anonymized data?
Mira, go ahead.
Sorry, Andrew, did you?
No, go ahead. I don't have anything to say about that.
I encourage you to weigh in on any of these. I'll try to talk less.
Sure.
I mean, I haven't looked at that specific sharing. Health information sharing has been problematic in a number of contexts. Most of the provinces do have their own health laws, which is good. Anonymization in the health context shares many of the same challenges that we have in other contexts. And I think like developing better solutions for how to assess that is good, because especially in the health context, it's very difficult to anonymize data in ways that are still useful, but are not to some degree relinkable back to a lot of the people that are caught up in that data set. So I think it's particularly problematic there, especially given it's very sensitive. Health data is generally very sensitive. I think that's all I have on that, but I'm not familiar with the particular information sharing challenge. I do know there's been a lot of sharing challenges around health information in general, and we do need to come up with better solutions for those.
Ange, next question.
Yeah, the next question is from Janet. Janet asks, are all of us in Canada videoed from the sky to keep our faces on file or in a database? I'm an environmentalist and a social activist. Does this mean I'm being filmed at protests, etc.?
So PIPEDA does. Sorry.
Go ahead. Sorry.
The answer is yes. Andrew actually tried to map CCTV compliant cameras that are compliant with PIPEDA over the years. I know because and other types of public surveillance tools that are compliant with PIPEDA over the years. PIPEDA has not. I mean, I think the answer is there's some limits on what you can do when you're publicly videotaping people, especially in sensitive locations, in sensitive contexts like at a protest. But generally speaking, this hasn't been prohibited by our privacy laws. I think with the addition of facial recognition and tools like that, I think we may see some more kind of aggressive restrictions in the future sometimes if those types of tools are being used in addition to video surveillance. I think also there's it also depends who's videotaping and for why. If it's for a commercial purpose and then it becomes kind of permanently online in ways that are not connected, for some sort of commercial exploitation or something like that, I think PIPEDA might also play a role. But generally speaking, that hasn't been something that our federal regulatory privacy law has provided a very useful solution for, and it can be very chilling for the people participating in those protests and have very negative implications.
Yeah, we could have a whole session, maybe we should, on video surveillance and facial recognition and how it's used and abused, and the sad state of protection about that. But we've got lots of questions to go and only a couple of minutes, so I'll forbear on responding at length to that. So Ange, can we have the next question?
Yeah, the next question, an attendee asks, what do you recommend we can do as individuals to protect our privacy? Can we take back, withdraw the personal data we've provided?
So you do have the right to withdraw consent, and C11 will kind of formalize what I think is already kind of required under our privacy laws, which is for companies to delete data that are, if you're no longer using a service, for example, to delete data that they've had. In practice, this is very difficult. And I should say, Canada is now in a regulatory fight with Clearview AI, which is a company that generated, a facial recognition capability based on profiles and images scraped from Facebook on many Canadians, and it was found to have done it unlawfully in Canada. But we're now in a fight with them over whether they can be obligated to delete those profiles or not. So we'll see where that goes. I think it's difficult. I think what we need is, this is why a regulatory solution is needed, because there's limits to what individuals can do. So like a regulatory solution that requires companies to minimize how much data they're collecting, how long they're keeping it, and do things more fairly is critical. There are some things you can do, like there's tools you can use that are more privacy protective. I was very encouraged, for example, when WhatsApp changed its privacy policy, like I think it was last year, in a way that made it clear to customers that data was being integrated with Facebook, that Signal, which is essentially a non-for-profit secure communications tool, saw a massive uptick in users. Signal basically does what WhatsApp does, maybe probably a bit more securely and with a few less bells and whistles. Those types of decisions I think you can make to kind of limit and minimize your privacy footprint if it's something to a degree you're concerned about. And I think we're increasingly seeing people do that, and it's great. But ultimately, we do need some regulatory solutions, because it's becoming impossible to navigate public life without being caught somewhere or other in these to-dos. Sorry, go ahead.
Yeah, just to add very briefly and to reinforce what Tamir is saying, I think the situation is becoming increasingly impossible for individuals, and that we need to shift much more of the onus on those that collect and process and use that information. And if we don't do that, the asymmetry of power and information between individuals and those organizations will become just increasingly impossible to deal with. So do what you can, but you can't solve the problem through individual action. You need collective and regulatory and legislative action, and that's where the battle needs to go. So we've got just a couple of minutes, so we have time for maybe one or two more questions. Ange.
Yeah, the next question, actually, an attendee asked, how effective are privacy apps?
I think they can be, and they're an important component. There's definitely other things that should happen. Andrew has some a really interesting kind of refund community initiative that he's part of, which is about funding making sure that there's funding for different types of community, innovation, development tools. I think universities could also be, really going into the creation of digital tools that, don't have a profit kind of, don't have this business model embedded into them, but are still can be very useful for people. We have government funding that's going to a lot of, all these super clusters that the federal government is paying into. A lot of that funding could also be diverted to community development of tools that don't have this driver in. And then there's also, again, as we mentioned, some things that individuals can try to do to minimize how exposed they are to this. But I do think that privacy laws have to be part of the discussion. This is an area where, the stakes are so high, both for individuals and for companies, that I think it's correct for a regulatory context to get involved, and for us as a society to make some of these decisions over what is and isn't acceptable. And privacy laws could be a vehicle for those decisions to get sorted. have been effective at discrete problems historically. They need to ramp up, but I do think that they have to be part of the solution, because it's very difficult otherwise to make any headway at all.
Okay, I think we have time for one more quick question.
Okay, the next question, an attendee asks, Europe has legislation on the right to be forgotten. Where are we on this in Canada? Do you know? I'm told that it is virtually impossible to get something about a person off the internet.
So it's actually before the courts, basically, is the answer. So there's a question before our regulator, and it'll go through our court systems as to whether the privacy framework itself allows for what's colloquially referred to as the right to be forgotten, which is basically the right to. It's actually, it's often, it basically manifests as the right to kind of delink your name from certain, to disassociate your name from certain either images or pictures on search engines like Google, for example. So it's not the first thing that comes up when someone searches your name. More generally, we do have a right to have information removed from companies like Facebook, because we have the right to withdraw our consent from the collection, use, or retention of our personal information once it's on there. Of course, that would mean we would have to stop using the service, but that right does exist. Kind of a form of it does exist. It's just not clear whether it extends to the more explicit kind of European variation that lets you basically say to Google in certain instances, this article has my very sensitive health information and it's not that relevant. There's no news to it, or this website has my very sensitive personal information on it. Please make sure it doesn't come up on the first page whenever someone searches my name. That question is still being resolved by our regulator and by our courts, and has not been explicitly addressed in our privacy reforms.
Well, we clearly could go on much longer. There are questions that we haven't been able to get to. I would have loved to have talked to you about harmonization of privacy regimes across Canada and internationally. There's a whole lot of other things, but sadly we're out of time. But I want to thank you, Tamir, for a very rich conversation. That you've helped us understand a very complex area, a very dynamic one, and one which calls us to I think become engaged with, particularly when that legislation comes back, and we'll see what we can make of that. So tomorrow, Ange will post a copy of our conversation on the website. So if you've enjoyed this, tell your friends, even your foes. I would very much welcome any feedback that you might have on this program and also on the series so far. I'm going to be taking a break for a month or so, but I'm looking forward to coming back and continuing these discussions. In particular, Liz Denham, who many of you may know was the UK's information commissioner, and formerly with the BC commissioner and federal commission. So that would be a very interesting discussion. She's going to talk about international privacy regimes and how Canada could play a leading role in that. So I'm really looking forward to that. So give us your feedback. Let us know what you'd like to hear about, and any suggestions for other guests. So I hope you'll join me again. So again, thank you very much, Tamir. We will be posting your book recommendations and other things that we've put up, we've mentioned in this conversation on the web as well. And thanks, Ange, for handling the questions, and to all of those who asked questions. And I'm sorry we didn't get to all of them, but I think they've been very interesting and stimulating questions too. So thanks. So back to you, Jim.
Well, I want to thank you, Andrew, for another really interesting and engaging program in our series. And Tamir, a special thanks to you. You were able to cover a lot of material, often very technical material, in a clear informative way. We're grateful for your participation. We may want to invite you back to have more discussion on these things. You're a real font of information and insight on these complex and difficult but terribly important issues. I also want to thank the audience for joining us today, and to mention that videos, this was the 8th in the series on Taming Big Tech, Exploring the Alternatives. In the event you'd like to look at any of the earlier ones, as Andrew mentioned, there are videos of all of those on our website, which is cfe.ryerson.ca. Also on the website, you'll see the many other programs we've had on other aspects of expressive freedom and the public's right to know. And I encourage you to have a look at those that may interest you. You also find on the website other resource material, blog posts on these issues, bibliographies, a whole variety of information, as well as information about upcoming events, such as the next in this series, which will be in May with Elizabeth Denham. So thank you very much for attending, and we'll look forward, hopefully, to see you at a future event. Bye-bye.
Bye-bye.